Morning everyone, congratulations on surviving the heatwave for now. So, it's an hour video, I know, but there's another problem that I think people aren't starting to pick up on yet, although it's been debated in the press at the moment. In the UK, your voice isn't actually protected in law the way that you might think it is. I mean, we all know great voices, Matt Berry being chief among them. And the commercial value of voices is obviously going up over time, matters more than ever. Voices have real commercial value for many people, Matt Berry in particular. The voice is their brand. You know, we're talking about voiceover artists, presenters, founders, influencers, recognizable tones, recognized delivery styles that brands will always want to pay for. So it's familiarity, it's trust. Sometimes it's serious revenue because of the fact that they're aligned with such talent. However, as far as the real world goes, we are already starting to see what happens when that control disappears. Stephen Fry, sorry about the flashing on my screens by the way, Stephen Fry recently discovered that his voice had been replicated using AI that had been trained on his performance in the Harry Potter audiobooks, and they were used to narrate a documentary you never went anywhere near. So you can imagine his reaction, pretty straightforward. He didn't say one word of it, it was a machine. Again, one of the most well-known voices in UK media, real commercial value, real history, real authority being used without his knowledge and certainly without his consent. So, legally speaking, we don't have a single clear right to a voice in the UK, like I said earlier. Or your likeness or even your identity. What we've got is a patchwork as opposed to a freestanding personality right. Certainly a voice performance, voice recording can be personal data, so data protection law deals with that. Copyright protects recordings and performances. Human rights law will obviously protect the use of private and confidential information, but none of them say, none of this gives you a freestanding right to say this is how you control the use and exploitation of your voice. You've got to use a few different tools in the toolbox. So you've got a jigsaw, a patchwork of other rights that might apply depending upon what's gone on. Certainly if you're using a voice to suggest an endorsement, then there's almost certainly going to be some kind of passing off claim there, maybe a trademark infringement. You can trademark a voice, funnily enough, in certain circumstances, although it's not common. And if a fake recording damages your reputation, that's defamation. There could be a privacy claim if it's involving, as I say, personal information, personal private information, but these are all only applied in specific situations. So if someone just recreates a voice, that can either mean that you need to knit all this together or a potential issue falls through the cracks. So really, this now comes down to contracts. If you're an agency, you don't deal with this up front. You're relying on a legal framework that is not built for the kind of tools that you're going to use these days, obviously AI being chief amongst them. What you should be saying, what you should be actually putting into these agreements, well, what we're advising on as standard are AI training. You know, you've got to be very, very clear that a voice recording can't be used to train AI models without very specific consent. From there, you can't clone somebody's voice, or you've got to agree that you can't clone somebody's voice. An express restriction on creating synthetic or simulated versions of someone's voice is going to be, again, we think pretty much standard as tech evolves, and tight usage limits. You know, we're not talking about usage in the original campaign, but reusing it. Adaptation, new formats are going to need fresh consent and fees, and more importantly, implied endorsement. You can't use somebody's voice recording in a way that suggests any support outside the agreed scope. Last of all, takedown provisions. You know, if the relationship does end, usage should stop. Anything derived from it should be deleted or taken down. Although obviously, if you're a brand, you're going to want to argue against that. But that's kind of the back and forth. That's the battleground. So again, without dealing with all this, you are allowing something valuable, that's a voice, something a brand would normally pay for, potentially, if you're the talent, to be replicated, cloned, reused without your control. You could end up in a situation where the original recording may have been authorised, but it's been put through the AI ringer, and the new version isn't, and the law doesn't necessarily give you an immediately clean way to deal with it, although data protection is certainly going to be one option and one that you may see people reaching for. But again, not just an IP issue, not just about performance rights and copyright. We're seeing this show up in client policies now, advertising rules on misleading content in particular, maybe even fraud. Martin Lewis will tell you all about that, where his likeness, his voice has been used in impersonation across the web for financial purposes, illicit financial purposes. So it's become a compliance issue on top of all that. So looking forward, the UK may be starting to think about whether or not we need a separate personality right for this kind of situation, given the way that the media landscape's evolving, but we certainly aren't there yet. There isn't necessarily the political will right now, but it is something that we might come back to in future. So the reality right now is this: your voice, people are sick of mine for a fair reason, has a real commercial value if you're a talent. The law doesn't necessarily treat it that way. Gives you other rights that might help you when something goes wrong, but not a one-stop shop. And in a world where voices are being cloned, changed, used in ways that weren't anticipated, that gap's only going to get bigger. So hopefully that's something that's worth thinking about if you're a talent or you're working with talent. I'm now going to spend some time catching up with emails after a basketball tournament with my son all weekend, hence the shameless NBA t-shirt. But other than that, have a great day. Use your voice. Type your voice in the comments if you've got any thoughts. Cheers.